Well, I have 6 o'clock, so welcome everybody to our monthly Money Life webinar. I'm Jim Allen, Senior Financial Planner here at Anchor Bay Capital. And little housekeeping, this will be recorded, so if you're not able to stay on for the entire thing, it will be posted to our website in a week or so. Also, I'll be happy to take any questions at the end of the presentation. You could just submit your questions through the chat feature or the Q&A feature. If you could, if someone could give me a thumbs up, let me know if you can see the screen, and if you can hear my voice, I'll know that we're in good shape here. Okay, great. So it looks like we're good to go. So as I mentioned, I'm Jim Allen. I'm one of the senior financial planners here at Anchor Bay Capital. I'm also a certified divorce financial analyst, a CDFA. And so I've received a special credential to work in the area of divorce financial analyzing. And so our topic today is to don't let divorce wreck your finances. So if you're contemplating divorce, or maybe you've started the process, or if you know somebody who may be considering getting divorced, we're kind of going to go through what the options are for divorce in these days, and then some of the pitfalls you maybe want to look at, some tax implications, things like that. So let's talk about some of the issues you're going to face from your finances. Obviously, we're not going to talk about things like custody of children or any of those kind of things. These are simply financial issues. And so we'll talk about what the modern divorce process looks like. And there are lots of different options for you, that range from the typical, lawyers all the way through just doing it yourself. Talking about a current trend that we see is what we call silver or gray divorce. A lot of baby boomers are going through divorce. So, they found themselves as empty nesters. The kids are out of the home. Long time marriages, they finally drifted apart. And so we see a major trend towards people getting divorced in their older ages, which creates some additional complications that you need to know about. We'll talk briefly about spousal support / alimony and child support. And then we're going to talk about, some of the big issues are like, okay, how do you split your assets, fairly, equitably? How do you avoid some big tax mistakes? And then, starting over. And then finally, I'm going to talk about what a certified divorce financial analyst is, and how a financial neutral like myself can be used in the divorce process to, make everything go a little bit smoother, probably make it a little less expensive, less contentious, and to get everybody off onto a good start in their new life. So the modern divorce process, as I mentioned, there's a lot more options today. Before you went to court, the lawyers argued over everything, a judge decided who got what. So now we have some techniques called alternate dispute resolution, where you don't get attorneys involved, or they're just involved in the periphery. And there's also been a trend towards what we call pro se divorce, do-it-yourself divorces. But we're going to talk a little bit about these alternate dispute sources. For example, mediation, collaborative divorce, those kind of things. But the typical approach, and for a lot of time, a lot of people, depending on how contentious the relationship is, maybe this is the route that you have to go, is litigation, where you're each going to get your attorneys. They're going to get all sharky. It's going to become very adversarial. You're going to battle over things like, how we're going to split the asset, who's going to get the pet, all of that kind of stuff. And then if the attorneys can't come to a settlement, then it goes to court and the judge decides. Obviously, the only winners in that, that approach are essentially the attorneys. Everybody else is pretty much a loser. So if possible, we want to try and avoid going the litigation route if we can. So a pro se or do-it-yourself divorce The idea here is, hey, you know what? This is pretty amicable. We don't have a lot to split up. Maybe it's a short-term marriage, and so let's just try and do it ourselves. And you can do that. In fact, about half of the divorces are actually done without an attorney. So it really is only going to work if there's an uncontested divorce. It's like, you go your way, I go my way. You take what you brought in. Their child support and custody and all those things aren't necessarily involved. So, to do a pro se divorce, you're still going to have to file and serve papers and all that. So it's still going to cost you between $1,500 and $3,000. But not having an attorney involved can just ease the temperature, lower that. And, if everybody's getting along okay and it's just, hey, it's time to, part ways, a pro se divorce might be able to work. And I've worked with clients on a pro se divorce where I'm, helping them figure out how to equitably split the assets, as a financial neutral. So this can work pretty well if it's a fairly simple. There are some issues. Obviously, if you're going to just do it yourself, you're not going to get discovery. You're not going to actually learn, what your spouse has or doesn't have. There's no recourse, down the road. So you're not going to find those hidden or missed assets. There could be unknown tax consequences. And then if you have things like pensions, this is really difficult to do because you have to have what's called a qualified domestic relations order, or quadro, to split that pension. But there can be a lot of situations where, pro se divorce is the way to go. And maybe you bring in, a financial neutral to help you with that. But you're going to file all the papers, et cetera, yourself and come up with a settlement agreement that works for both of you. So, next is obviously the litigated divorce. Each spouse gets their attorney. The attorneys advocate for their client. And, they're either going to negotiate a settlement between the two parties, or if it can't be negotiated, then it goes to court and a judge decides who gets what. It's obviously the most adversarial systems. Attorneys have been trained to be the advocate for their client, so they're going to fight tooth and nail. And so, it can get very contentious, very adversarial, and, it's going to rack up the biggest cost because these attorneys are going to, keep going back and forth and trying to get top dollar for their client, which also gets top dollar for them. And, it may be necessary if, again, it's contentious, things are going to be fought. Maybe you think that there's asset hiding going on or things like that. So, going through the discovery process and getting legal advice, sometimes that's the best option for you. Just know that it's going to be costly. It's going to be more drawn out. It's going to be far more stressful on you. And then also know, ultimately, if you can't come to a settlement between your attorneys, you're going to court. And now you're losing control over everything because now you have a judge who doesn't really understand the family dynamics, the situation. They're just looking at, the numbers and what the attorneys have said. And they're going to make a decision, based on pretty limited information. But if it's an ugly divorce, it's a contentious divorce, you're probably going to have to go the litigation route, unfortunately. My advice would be, if all possible, try and avoid this, or at least start with one of the other approaches. And then if it has to go litigation, have it go litigation. There's a couple other alternative approaches that are used more frequently. The first is what we call collaborative divorce. This one isn't as common as the next one. We'll talk about mediation, but this can work pretty well. So what you have, it's a team-based approach. So you have a team of professionals who work with the couple. So it's not like each couple has their attorney advocating for them. They have the team advocating for the best outcome. So the way that a collaborative team would typically work is each spouse would have an attorney as part of the team, but the attorney is, going to not necessarily advocate just for their client. They're going to keep the client informed and advise them, but they're going to work as a team to come up with a settlement. A lot of times you have a coach who's going to guide everybody through the process, keep the temperature down, keep everything moving along smoothly. And then typically you also have what's called a financial neutral, which is where I would typically serve a role, where the attorneys are going to discuss all of the various options with their particular client. The coach is going to keep the process moving along. The financial neutral is going to evaluate the settlement options that the team comes up with, and then they ultimately come up with one. Okay, this looks like it's going to work the best for everybody involved. So here's the financial settlement. The attorneys talk it over with their client, and then they become, they come to an agreement on, this is going to be the marital settlement agreement. If there's children involved, or if there's been abuse or something like that, then maybe sometimes as part of the team you'd have a child specialist or a therapist who would kind of again be the voice for the children in the marriage and things like that. So collaborative divorce is this team of professionals who are working for the benefit of the client, the two spouses, not just one of the spouses. And so it can work out far better if you can go this route. So the way it works is the team is designed to be non-adversarial. So if all of a sudden the collaborative process is breaking down, then the whole team has to withdraw. And so the benefit to this is each spouse is going to have their own attorney, but they're supposed to be working as part of the team. And so if they start getting sharky, then the collaborative process stops. Everybody has to withdraw, so that attorney who's maybe kind of blowing up the process can't then work for the spouse who they were essentially representing. So the team is the advocates for both spouses. It typically, if there's children involved, it's going to include that child specialist is going to be the advocate for the child and bring up the issues that may affect the child. The financial neutral is working on a fair and equitable settlement for both parties. The coach keeps the process going. And so the cost is generally much lower than litigation would be, but it's going to be higher than the next option, mediation. So depending on the team makeup, it may be $15,000 to $30,000 to go through a collaborative divorce, where it's typically $30,000 to $50,000 to go through a litigated divorce. The next approach, and the one that seems to be gaining the most traction, becoming the most common, is what's called mediation. So the spouses jointly determine the outcome. Now, it's not binding, so it's not arbitration, and the whole process is voluntary. So you hire a mediator. They're typically an attorney or a judge, someone like that who's been trained in mediation, and the mediator works with both spouses to come up with an agreement. So the mediator is supposed to be neutral. They're not advocating for either side. They're not making any decisions, and they're also not giving any legal advice. But they help both clients understand the issues and hopefully come to a resolution that both parties can agree to. Most clients, may or may not have an attorney. Usually, once the mediation has finished and the clients have come to an agreement, then there's going to be an attorney who's going to draft the marital settlement agreement. But the mediator helps guide the clients through this process, helps them come to a mutual agreement that everybody's happy with. Far lower cost than either litigation or collaboration. It's usually $5,000 to $10,000 per spouse. The problem with mediation is it only works if everything's pretty amicable and both parties are willing to be involved in it. They're actually going to participate. Then it works really well. And then again, you may bring in a financial neutral to help work through all of the financial decisions that have to be made, show the tax consequences or whatever, and show those potential settlement, financial situations to both spouses, and then the mediator helps them come up with the agreement that works the best for them. So, mediation is a very good way to go if the relationship is such that you could do it. It certainly is going to save everybody money and typically come up with a resolution that's going to be better for most everyone involved. So we kind of look at it as a spectrum. On one end, the lowest cost is a pro se, just do it yourself. And it also requires the best relationship because you're doing everything together. You both have to be on the same page. You both have to be willing to agree to everything. And the next, in terms of cost, is mediation. And also, you still have to have that very solid relationship for mediation to work. Kind of in the middle is collaborative divorce. It's not the cheapest. And, there can be contention, but you have this team of people who are going to help you work through all of that. They've been specifically trained in this process. And so it's certainly a lot less expensive and a lot less contentious than, going to litigation. But, if it fails, then typically the team's going to withdraw and now you're going to litigation. So it could potentially be more costly to go collaborative if you're not sure that, both parties are willing to go through the process. Next, obviously, you would have a settlement with, the two attorneys negotiating that. And then finally, the worst relationship and the highest cost is going to be it's going to court and a judge decides because there's going to be far more attorney involvement in that. There's going to be court dates and all of that kind of stuff. So you can see, if the relationship's actually pretty good and people are just going to part ways, on a friendly basis, you could do pro se mediation. If it's kind of in the middle, you could do mediation collaborative divorce. But if the relationship's, not good, the only options are attorneys and court. And obviously, you better have the funds to do this. And unfortunately, what I see a lot of times is one spouse has the funds to be able to, battle this out in litigation in court. The other spouse maybe doesn't necessarily have the resources, and you end up with unfair settlements in that situation. So that's the process. So now let's talk about senior silver divorce. Gray divorce is another term for it. So this is the fastest growing age group for divorce. I would say in the cases that I've worked in, in the last 5-6 years, I'd probably say 60% of them were baby boomers. And so, the rate keeps increasing. A couple reasons for that. One is increased longevity. It used to be couples got into their 60s and then, one of them typically passed away. Now with, couples living into their 80s, 90s, or even older, you're together for a much longer period of time. And so, the likelihood that you're going to drift apart, or you may decide, what, I've been unhappy for a very long period of time and, I want to enjoy what time I have left. So I think that's why we've seen the increase in senior and silver divorce. But it brings more complex issues because people in this age demographic, typically, they've been accumulating for 30, 40, 50 years. So they have more assets to divide. They have 401ks, they have pension plans, they have real estate, they have homes, they have Social Security benefits, all of that kind of stuff. So, the situation is more complex, typically involves more analysis. And, as a CDFA, I think I work a lot more on these kind of cases because there's just more to split up. And then also, now if you're dealing with, you're in retirement already and now you go through a divorce, splitting up assets could essentially, put both spouses in a very difficult situation financially. And so typically you need more help to make sure that, you don't end up wrecking both of your finances because of this gray divorce. So let's talk about what the process is in California. So like most states, California is what's called a no-fault divorce. So you don't have to prove that the other spouse did something wrong to get out of the marriage. You can just decide, hey, we're going to divorce, and you start the process. So the first thing you do is you're going to complete those divorce or separation documents. And again, if you're doing it pro se, you do it yourself. If you're using an attorney, or a mediation or one of the other processes, then someone's typically helping you fill out those documents. So one spouse files them with the county, and then the other client is served. So a lot of times it's one spouse who wants to start the process, and the spouse who's getting served may or may not even be aware that a divorce is impending. So then you have to file financial information with the other spouse. And so you have these kind of disclosures you have to provide in terms of, these are your income, these are your expenses, these are the assets you own, all of that kind of stuff. So each spouse can see what, the assets are that we're going to be dealing with during the settlement. And then you may have other issues like requesting child support or custody or those kind of things. And again, I'm not going to talk to those because I deal specifically with only the financial aspects of it. So then you're going to go through the process, whatever that process is, whether it's pro se, mediation, collaboration, or litigation. And so then the divorce agreement is going to be negotiated. And so essentially, the spouses can divvy up their assets any way they want. They just have to agree upon it. If they can't, that's when you go to trial, and then the judge decides. And here, some things are already kind of set in stone. And so it's far, far better to try and negotiate a settlement than it is to go to trial because there really aren't any winners. And then finally, once you've either negotiated the settlement and you've drafted the marital settlement agreement, or you've gone to trial and the judge has made their rulings, then the divorce is final 6 months and 1 day after the respondent is served. So the spouse who's going to receive the divorce papers 6 months after they're served, you can essentially have the divorce finalized. So there's kind of a cooling off period here, to make sure that everybody wants this to get completed. Okay, so talk a little bit about child and spousal support from a financial aspect. So child support is formula based. Each state has their own guidelines on, how much the child should receive, based on income and based on, who has custody and visitation and all of that. There's a formula. It's typically called a disomaster. That you put the numbers in and it spits out what child support should be. Child support is paid until age 18. It can be negotiated or modified. So, the disomaster kind of comes up with a number, and if you don't negotiate something ahead of time, that's going to be the number. But it can be negotiated up or down, depending on what the spouses agree to. And then it can also be modified. So circumstances change, spouse loses their job, or, maybe one of the spouses is now making a lot more money. You can go back to court and, modify the child support agreement. Or again, you can just negotiate a new agreement. What you need to know about child support from a tax standpoint is it's not taxable to the recipient, and it's not deductible by the payer. Now, the other typical payment that's done is what's called spousal support or alimony. And so where child support is basically formula-based, spousal support is subjective-based. And there's a bunch of factors that go into it. It's like, okay, what is the need, the financial need of the spouse who's going to receive spousal support? What's the ability to pay of the other spouse who's going to have to pay it? And then things that come into play is like, how long was the marriage? If it's a short-term marriage, spousal support is generally not going to be a lot, and it's going to be for a shorter period of time. If it's a very long-term marriage, it could be for the life of the spouse who's receiving it. You also have to look at the lifestyle, what expenses is this spouse going to have that need to be covered through spousal support. But then you also look at the age, the health, and the employment. So, even if it's a long-term payment, in most situations, say the spouse is going to receive spousal support isn't working, the court's going to expect that spouse to go back to work at some point. So there may be a period of time where they'll pay spousal support, for the person to get some education or training and then go find a job. But generally, there's an expectation. It's like at some point you have to become self-sufficient. The one big exception is very long marriages. And so, the payment length will vary, again, depending on all these factors or depending on what's negotiated. But what typically happens is spousal support stops at either the death of the payee. So the person is paying spousal support when they die. Obviously, spousal support is going to stop. It also typically stops if the spouse who's receiving spousal support remarries. So, it may be that, the spouse is going to have to pay $5,000 a month for 10 years. If the spouse who's receiving that, remarries 3 years from now, the spousal support would stop. Or if the spouse who's paying it dies 3 years from now, the spousal support would stop. In terms of taxes, under, essentially after 2019, spousal support's not deductible by the person who's paying it, and it's not taxable to the person who receives it. So spousal support can be negotiated, and even if it's not negotiated, it's going to be very subjective as to how much you're going to get, how long you're going to get, etc., based on a whole bunch of factors. Where child support, it's pretty cut and dried. You put in the income and expense numbers, you put it into the DISO master, and it kind of spits out a number. But again, you can negotiate any of this stuff. It's just where these formulas and things like that are going to come into play is if you don't negotiate it and come to an agreement. Okay, so now let's talk about splitting up the marital estate. So, generally what's going to get split up in a divorce. And again, it can all be negotiated, but let's just say that, it's going to go to court or whatever. This is the way it would work is in California, which is community property, half of the assets that are compiled during the marriage would be considered community property. So each spouse would be entitled to half of the community assets. Now, assets that are separate property, they were either brought into the marriage or they were inherited and they've been kept separate. So they haven't been commingled, into joint bank accounts and things like that. Those generally would be considered separate property, and they can be kept out of either negotiations or they would be kept out of, a judge's decision, a court decision, those kind of things. So, the thing about separate property is for it to be left out of the divorce proceedings, you need to keep it separate. So if you inherit, funds, you want to keep those separate in your own name only if there's a potential that there could be a divorce down the road. So, what do we typically see that gets divided? The biggest asset is almost always the home. And, this is the one that can get pretty complicated. It's like, okay, what do we do with the home? One spouse, do they want to live in it? Maybe there's kids involved and they want to keep them in the family home. Okay, great, but can they afford that? Can the spouse who's going to stay in that home, can they afford to keep the house? If there's a mortgage, can they pay the mortgage? Or can they qualify for a mortgage? How long are they going to keep the home? Are they going to agree to, one spouse with the children stays in the home for, the next 6 years till the kids are adults and then the house is sold? You have issues with the mortgage. Usually when there's a divorce and one spouse is going to stay in the mortgage, or stay in the home, they're going to have to qualify for that mortgage on their own. And maybe they can't do that. I see that as a common issue is, I want to stay in the home, but I've got a $500,000 mortgage and I'm not going to have the wherewithal to qualify for a $500,000 mortgage on my own, because in the vast majority of cases, the mortgage company is going to make you requalify to keep that loan. A lot of times, the option that's going to be kind of default is we're going to sell the house. Even if someone wants to keep and live in it, if it's not feasible to do that, we got to sell the home, and then we're going to split up the proceeds. But that doesn't have to be done immediately. You can again negotiate. Hey, we'll sell the home in 3 years or 5 years, or whatever it is. So you can negotiate that. And so there's a lot of different ways you can come up with that. The next other big asset are retirement plans. So that's your 401ks, your IRAs, your pension plans, and all that. Those are fairly straightforward. If you say there's $1 million 401k that's going to be split 50-50. The spouse who doesn't have the 401k would just roll over half of that 401k into an IRA in their name, and that's how you split it up. Now, a pension is more complicated, because then that's where you have to do the qualified domestic relations order, and the pension doesn't get rolled into an IRA. It gets split where the non-employee spouse is going to be entitled to some of those pension benefits down the road, but this qualified domestic relations order accomplishes that, and these are extremely complicated. You normally have to hire a professional who specializes in quadros to get that done. Then obviously you got your investments, your bank accounts, and your brokerage accounts, and maybe other real estate and all of that. So we have to decide, okay, how are we splitting these up? And personal property, cars and collectibles and all that. And a big one I see, excuse me, it can be pretty contentious, are pets. Who's going to get the family pet? And that can oftentimes be a big sticking point. Are you going to have joint custody of the pet? And again, all of these things can be negotiated. And this is where someone like myself, as a financial neutral, would typically get involved and help them analyze, okay, how are we going to divvy all this up to be, the fairest to both of you, and based on the assets, what's the easiest to split up and all that. So we would come up with various scenarios to show you, we can split it this way, we can split it that way. Here's the consequences financially and tax-wise to these various splits, and then we come up with a scenario that works best, and it becomes part of the settlement agreement. Okay, so let's talk about some of the tax issues in divorce. So while you're still going through the process, you're still technically married. So if you're married on December 31st, you're married. So you're either going to continue to file jointly with that spouse, or you can married filing separately. And again, California is a community property state, so it's not just, hey, I made $10,000 and my husband made $100,000. I'm going to file separately and only report $10,000. That's not the way it works. There's a bunch of complications to go into that. So we would have to analyze what's the best approach for the couple jointly. Is it to file jointly? Is it to file separately? And again, if we're going to file jointly, both spouses have to be willing to do that. And so, we have to kind of negotiate that as well. Once you're divorced, then you're either going to be single or you're going to be head of household. So if you're divorced and you have dependents like children, you can file as head of household, and it gives you some additional tax benefits. So that's the filing status until you're legally unmarried on December 31st. You're still married, and you either file jointly or separately. Once you're actually finally divorced, again, if you're single, treated as single at the end of the year, you're going to file either single or head of household. In terms of splitting the assets up, what are the tax consequences to that? In general, transfers between spouses because of a divorce, there are no tax consequences. So if one spouse gets the house, then there's no tax consequence to that person getting the house. Kind of the one exception to that, obviously, is if we're dealing with retirement plans, those get split But again, the 401k needs to roll to an IRA in the non-employee spouse's name in order to avoid tax consequences. You have to use this quadro to split the pension, or there's tax consequences. And if you're going to sell the home, which is by far the most common approach that we see, is you could have potential gain on appreciation in the home, but you would still have the $500,000 exclusion, to hopefully minimize gain. So this is where having the financial neutral again comes into play. Is we don't want to make decisions that are going to cause tax problems, as part of the divorce. Again, that's where going pro se a lot of times can be tricky, because you could end up doing things that create tax headaches down the road. So let's talk about some of the common divorce mistakes that I see. The first one is not uncovering all the income and assets. So, I work in a couple of different situations. I'd say by far the one that I do most commonly is work with one client. So clients are getting divorced. One spouse comes to me and say, "Hey, I'm going to get divorced. I don't know what everything is because I haven't been involved in the finances, or there's concerns that maybe the other spouse is hiding assets or has been taking assets out of the marital estate or whatever." And so, there may be need for, income tracing or forensic accounting to uncover some of that stuff. Or a lot of times it's just you need someone who understands these things to kind of look at the disclosure documents and, uncover issues. For example, if I'm looking at, a tax return and I see that, there was $10,000 of bank interest, and, the spouse isn't showing a large bank account, I know there's an issue there. Because, if the bank's paying less than 1% interest and there's $10,000 of interest, someone has a big bank account. And we can uncover those kind of things. And then the next thing is not all assets are created equal. For example, if one spouse gets a $1 million home and the other spouse gets a $1 million IRA, the home is not 100% taxable because you paid into it, plus you have your home exclusion and all of that, whereas the IRA is going to be 100% taxable when you take it out. So if I get a home, maybe I only have a small amount of capital gains, if any, versus if I inherit the IRA, I may only get $700,000 of that IRA. So we need to true up the asset division based on the tax consequences of the assets that are being received. And so we definitely need to consider those tax implications. And that's where, again, we would do a true up, or what we call tax affecting the distributions, to make sure that, after taking into account the tax consequences of these assets, is it still pretty equal to both clients. Next one's incorrectly dividing the assets, not doing the IRA rollovers or not doing the quadro, things like that. And then, the other one that's a biggie is just not completing the process. So yeah, maybe you get the paperwork, you get the marital settlement agreement, but have you closed out all of the joint credit cards? Have you updated your, beneficiary designations on your retirement plans, all of that kind of stuff. So even though you finished the marital settlement agreement, or, the judge has decreed the divorce final or whatever, there's still things that need to be done. Otherwise, they'll fall through the cracks. And then the last one's choosing the wrong divorce process. So, if it's pretty amicable, you definitely don't need to go see an attorney. You'll save yourself a lot of time and headache, and you can get through everything with much lower cost. On the other hand, if you think I'm going to just try and do this pro se, but one spouse is not participating, they're stonewalling you, that's not going to work either. And maybe you have to, to get attorneys involved and go through litigation. So then, we've made it through divorce. We've gone through the process of whatever process we're going to use. We've come up with a marital settlement agreement that is fair and equitable. We've come up with spousal support, child support, all of that. So now you're going to be starting with a new financial life. And so this is where I would take off my CDFA hat and put on my CFP hat and say, okay, this is your new reality. This is what you're going to have to work with. Whether you're going to have your own employment, you're going to have spousal support, maybe you're going to turn on Social Security, this is your reality in terms of expenses. You're no longer living in that house, you have to rent, all of those kind of things. So, we've got to create the budget and look at the spending plan based on the new reality. We also, a lot of times, again, in these gray divorces where maybe one spouse stayed at home and raised a family, they don't have their own financial identity. So we've got to get credit established for them and, do all of the things that they normally haven't been involved in and get them self-sufficient in terms of establishing their own financial identity. We need to make sure that insurance policies are updated. You don't want to have that ex-spouse named as the beneficiary on your insurance policy because that beneficiary designation overrides the divorce decree. And so, if your ex-spouse is named on your life insurance, you pass away, they're going to get that life insurance. It's not going to go to your kids or your trust or anything else. We need to update your estate documents now. So, are you going to have your own living trust? Do we need a, new will, financial power of attorney, healthcare directives, all of that? Who's going to be now your, successor trustees and all of that kind of stuff? Need to update your employee benefits. Do we need different health coverage? We update the beneficiaries on your retirement plans, all of that kind of stuff. And so it's essentially developing your financial plan based on your new reality. And unfortunately, in most cases, the new reality isn't always as good as what they had before. Now, mentally and psychologically and emotionally and all that, it may put you in a far better situation. Oftentimes, it doesn't put you in a better situation financially. And, my job as a CDFA and CFP to help get you there. And then finally, you're going to have to deal with the non-financial issues, relationships. Like maybe you had friends as a couple. And so how is that going to work in the future? And, how is this going to work in terms of, child custody and back and forth and grandmas and grandpas and all of that kind of stuff. So, you get through the divorce, that's really just the beginning of, a new financial reality for you. So, what does a CDFA and a financial do? As I mentioned, we work in a bunch of different ways. Probably the most common is we're working with one spouse they're going to get divorced, or maybe they've started the process, and they want someone to just be in their corner and look at everything from a financial standpoint and advise them on, yeah, this is fair, this is not fair. These are assets that we think are missing, all of that. So, that's probably the most common way we work is one spouse who's either getting ready to do this or they're in it and they just want someone who's not an attorney, because attorneys aren't trained in all of this, to just look at everything from the, with a new set of eyes on the financial aspects. Sometimes we work with both spouses where they're going to do a pro se divorce. I just did one of those last year where, it was very amicable. And so I just helped them split up the assets fairly. And then they completed all the documents and did the divorce. A lot of times it's, again, kind of behind the scenes. And I do this sometimes with family law attorneys where I'll do the asset tracing or the forensic analysis because it's probably more efficient and effective to have a financial professional look at these things than, to have someone in a law firm, do this. And then often I work with mediators or as a collaborative team, probably more frequently with mediators as a financial neutral, where, I'll either, again, work with, the mediator to help the couple come to a financial resolution. I can assist with the tax analyst. And then, once the divorce is done, obviously then, we deal with the financial planning specifically for the client that we're working with. So we see that a financial neutral can be a really cost-effective way to get this done far more amicably and far more cost-effectively, by keeping everybody informed and coming up with a variety of fair and reasonable financial settlements that will work for both people. So with that, hopefully it gave you a little bit of a taste of what the whole divorce process is. I'm happy to entertain any questions at this time. And again, this has been recording, so you'll be able to view this on our website in a couple weeks. If you want to reach out to me with your questions, you can certainly send me an email. My email address is here, or you can reach out to our office and we can schedule a consultation or whatever you need. And so again, the main thing is do this as early in the process as you can. So let me just see if there's any questions here. Okay, so question I see is how much are quadros? Who does them? They're going to vary based on the complexity of the pension plan, but some lawyers do quadros and some CDFAs do quadros. They're people who specialize in these because each pension plan has their own rules about how it has to be done and everything, and there's major consequences. Like I don't do quadros in my practice. I would refer someone to a specialist who just drafts quadros. And again, you don't need these unless there's a pension involved. But if there's a pension, there's a bunch of analysis that has to get done on how the pension is split up, because it could be that, maybe you worked for a company for 30 years, but you worked for them 10 years before you got married. And so, the distribution is not going to be 50-50. There's allocations and ratios that have to work there. Those are the kind of things I do as a financial neutral, but when it comes to actually drafting the legal document, there are specialists who do that, and I would highly recommend that you use a specialist to get a quadro drafted. Let me see if there's any other questions, and it doesn't look like there is at this time. So again, I thank you for coming out this evening. As I mentioned, feel free to reach out to me with any additional questions, or feel free to refer this webinar to someone that that may be contemplating divorce. Alrighty, guys. Well, have a great rest of the evening, and we will talk soon. Thank you.